Welcome again to the Senior Symposium. This is one of a series where we help to motivate and educate the public out there in Salem and Kaiser, surrounding areas, about what's happening with the older generation. And for those of you who are younger, you may have parents or grandparents that would benefit from any of the notes you take here. So let's do it. Get out your writing pad and take notes at your leisure. I am B. Lee Coyne, a longtime gerontologist since 1975, starting out in New York, then Metro Washington, D.C., then New Mexico, and now finally here in Salem, Oregon. And I've taught courses in aging, and I've counseled, and I've written online and elsewhere columns on the future older generation. So that's where I'm coming from. I'd like to introduce our two experts today, quasi-experts, shall we say. We have elder law attorney John Gear, very much in gear, giving us some legal advice and understanding. And we have Susan Jones, a retired social worker, one-time ombudsman, actually, I learned earlier today. And Susan used to be the social service coordinator of the programs at Northwest Human Services, a very well-respected agency here in town in Greater Salem. So what we're going to take up today is the topic of disability. Very often people look at life and death and they sort of forget the in-between part of living. And the in-between part is we could become disabled. We could become run down. Our bodies decline a little bit. Sometimes it's 60, 65, 70. And when we're in that little twilight zone of aging, how do we handle it? And what are the resources, the remedies to make life a little bit more bearable? Any thoughts on that, Susan? Let's start with Susan.
Well, as we age, we often have questions about how are we going to manage.
Exactly.
Things fail us, and we need new services and that sort of thing. And so the question might be, where do you get those services?
And how do you cope with change?
Yes, yes.
That's the big bottom line. Life is changing faster than you could keep up with. And it's almost like outrunning an Olympic athlete, only the athlete is getting stronger while you're getting weaker.
Yes, that's true. And sometimes you, as an older person myself, I realize that I am in denial about what's happening to me. Mm-hmm. And I don't know it until it's quite late in the game.
Sneaks up on you.
That I need some help. Yes,
mm-hmm.
Yeah.
John is not quite a fully older person, but he's getting there. John, tell us a little bit about your non-legal perspective of what aging means to you and what you have to watch out for.
Well,
zap, zap, zap.
First of all, I need to say thank you for having me here. I did want to correct, you said I was going to be giving some legal advice.
You will
I want to make sure that
but
listeners...
Education.
Right. Listeners know that I can't give legal advice to you because I don't know you. I don't know your facts.
Right.
And but that's really an important point, is that you can't take advice that's meant for the general public. Your father, your mother, yourself as you age, everybody's different. And you can learn from the experiences of others, but if you need assistance, you need to get advice from people who know you and your situation, whether that be your doctor, your minister or pastor or rabbi or imam. You can't, people aren't cookie cutter products. People are all different. And so don't take legal advice that's meant for the general public as if it was right for you. Mm-hmm. Similarly, don't take medical advice that you read in the newspaper as gospel. Aging is different for everybody.
Exactly.
We all have a different genetic inheritance, and we all have a different lifetime of experiences mm-hmm. and things we've done to our bodies that are good or bad or indifferent. And the important thing, and you mentioned, feeling like you're trying to outrun this athlete mm-hmm. as you age. The important thing about aging and preparation for a good elderhood is that you have to do your preparations long before you're aware of the need to do those preparations. Essentially, the decisions you make in your middle age have far more to do with your quality of life as an elder than the things you do as an elder. It's like you can't pack the parachute once you've jumped out of the plane. And becoming an elder, you have to pack that parachute before you jump, and you have to get your affairs in order. This program is about disability and decline, perhaps.
Exactly, yeah.
And one of the most cruelest things about disability, particularly mental disability of elders, is that we all want to think we're with it and we've got our stuff together, and if we begin to decline, we'll do something about it then. Well, it's like alcoholism. By the time it takes you, you aren't able to do anything about it. Once you become demented or suffer from dementia or some progressive crippling disability, you may not be able to do anything about it. So that's why preparation, when you feel great, when you're young, is so important, because if you want your wishes respected and you want to be able to be in control of what happens to you, you have to take steps well in advance of need.
Okay. John, if I were to write a headline across the Statesman Journal, say, beware the 11th hour remedy.
Excellent point.
That's how I put it all together.
Because your clock may be off, and you think it's the 11th hour, but actually it's past midnight and it's too late. I have had people come to me in position thinking that they're going to come now and do some estate planning now that they realize their need. And in their lucid moments, they do realize their need, but they're no longer competent to make all their decisions.
Okay.
And so people need to help other people recognize it's time to plan now.
Comment, Susan?
Well, I have two experiences that illustrate how right he is. One is I had a friend who was getting older, and she realized that she was not really able to do her finances anymore. It was pretty late then, but she was able, with her attorney, to appoint a conservator and a guardian.
Wonderful.
And so I served as her conservator, and she lived, 15 years longer than that. And this particular woman had quite a big estate, and she had many needs as her age disability took her over.
Let us define for our viewing public out there, what is a conservator and what did it consist of for you? And then John will add his perspective as well. What is a conservator?
A conservator is a person that takes care of the financial and all the property of a person who
Is disabled.
Is disabled, yeah. And so the court appoints the conservator. Then the conservator has to handle that and give reports to the court every year through the attorney, and that has to be approved and so forth. That person has to be bonded, and the estate has to pay for that.
So a conservator is essentially the guardian of the money. If the shorthand phrase is if a guardian is the guardian of your well-being, your physical well-being, the guardian makes sure that you are cared for properly, have a place to live, are eating nutritiously, that sort of thing. The guardian of the body is called the guardian. The guardian of everything else, all your assets, is called a conservator, meaning they're conserving the estate, the property you've assembled, and they're legally bound to act in your interest. The conservator has a person called the protected person, and that's the person who, her friend who approached her. And the protected person, that relationship creates a legal duty to act for the benefit only of the protected person. And every decision you make as a conservator will be examined by the court to make sure that you're acting for the benefit of the protected person and not for the conservator's benefit.
Okay. Let me do a follow-up question. What are the criteria or standards to qualify to be a conservator, and who judges whether you meet that test?
Well, the trusted friend, preferably maybe a younger friend or a healthier friend, but certainly somebody who is trustworthy. The court ultimately decides, the probate court in Oregon handles conservatorships and guardianships. And the judge on the probate bench will decide whether this proposed guardian or conservator is appropriate. Things that they look askance at is bankruptcies, any evidence of addictions, any prior indication of abusive behavior towards others, towards a vulnerable person.
Criminal record?
Criminal record, if it's
violent, I guess.
Yeah, well, any abuse towards others would be a red flag. But your childhood conviction for something probably doesn't disqualify you. It's a case-by-case thing.
Right.
But the main thing is that it be a trusted person, or if the protected person isn't nominating the guardian or the conservator, that it's somebody who is without question, someone who puts their duty to the protected person ahead of their own interest. Obviously, Sue was the perfect candidate for her friend, and a trusted friend, the kind of person who you would make the guardian of your children should you pass, and if you die with minor children, that is also the same person who you would want to make decisions for you if you were unable to make them.
Okay, good. Susan, tell us what it was like being a conservator, what the ups and downs, the speed bumps, as well as the goodies.
Well, the one difficult thing was that my friend had neglected her finances, and she had been, before that, she had been handling them, but she'd forget things. And so when I took over, it was quite confusing. She had many accounts in many banks, a lot of different investments in different companies and all that. So it took me a couple of years to really get that all straightened out. And then the reports were difficult in her case.
This is a cautionary tale to those out there. Make sure if you're in your 40s or 50s, try to consolidate and have it listed so that if you do become disabled, the person appointed as your conservator can figure out which end is up and which is down. Go on.
That's a good point. And and then another difficult thing was for her, because she had a complicated and large estate, making the reports every year. I had to list every expenditure and every bit of income, all that. And it all had to balance, and I had to have all the documents there to show the court and that sort of thing. So that was a big deal. After a few years, it got to be easier because I had it straightened out in the first place. And I was lucky to have the support of the attorney. So
important.
I had instruction from him, but I also had him checking my work and telling me exactly what was required and all that kind of thing. And then one of the wonderful things about it was that she also appointed me her executor of her will. And in her will, she gave all her money away, and she had a lot. And so I got to write the checks to all these places to give them a lot of money, that she had.
Some are charitable groups and
charitable groups, yeah.
Okay.
A few individuals, but yeah.
Very
So that
noble.
was a fun part.
Okay.
We had to liquidate all of her belongings in her house and everything like that.
That could be a headache.
It was it was hard work, but it was fine. I was happy too. She was my friend, and she had nobody else in the world except this guardian who was
you came
also
to the
a
rescue.
friend. Yeah. So I was glad to do it.
John, did you want to weigh in on that?
I think what people are going to want to ask is, were you compensated in any way for your work?
Yes, I was. At the very beginning, I had to establish a fee for my work, and I charged by the hour, so I had to document every hour of work, what I did specifically during that hour. So that was a part of the report too. And so I got paid that much.
Right.
And it was paid in a year. It wasn't paid every month or quarter or anything like that. And as the executor of the estate, I was paid 1% of the estate for my fee for doing that work.
Is that pretty normal?
I think it was because the attorney told me that's what I got paid. I didn't.
It's pretty.
I didn't establish a fee or anything.
It depends on the size of the estate. I mean, a really massive estate, that percentage might go down.
Oh, that's right. Yeah.
But you know, for the size, I'm sure it was appropriate because again, the probate court passes judgment. The proposed payment each year to the conservator is approved by the court, so it has to be a reasonable fee for the expertise of the person, the complexity of the affairs, and you know, the idea is simply to make sure that you're not making you're not excessively draining the estate to reward yourself. The idea is that you are the agent of the protected person, and your role is to safeguard their estate.
Okay. John, let's move from money to mental health. There's a phrase called mentally incompetent or something of that nature. Who decides when a person, if they resist calling themselves mentally fragile or incompetent, how does the court find out, and how does the court confirm or affirm that the person can no longer handle their own affairs because of mental deficits?
It's very difficult. If the protected person, the prospective protected person,
yes,
if someone has filed a petition for guardianship with the court, saying, I think mom needs a guardian, mom is no longer taking care of herself, that sort of thing. If mom keeps getting on the bus to go to Omaha, Nebraska, a place that mom's never been before, but suddenly mom is fixated on, I'm going to go to Omaha, I've got to go to Omaha.
Strategic Air Command, I got to say it.
Well, whatever it is, I mean,
Boys Town.
elders in their dementia is cruel sometimes, and it gives them these fixations. And if you find a person who's suddenly fixated on going to Omaha and they've never been there and they can't drive anymore, so they call cabs and they ask the cab driver to take them to Omaha.
It's some cab fare.
Astonishing things.
From Salem.
So you end up going to see an attorney, and the attorney will file a petition for guardianship, an emergency petition for guardianship in that case, and then a permanent guardianship. And then the court will appoint what's called a visitor. And I'm sure you both know about court visitors as social workers. A court visitor is the eyes and ears of the court out in the community. The visitor will go and interview the prospective person to be protected, and then interview the family members, interview the person who filed the petition, the petitioner who sought the guardianship, and has a very detailed format report of questions the court wants answered about the protected person and also about the nominated guardian or conservator. And then if the person has filed an objection, if the person who's losing it, we could say, it's very easy for them to file an objection. The court is very open to hearing their objection.
Right.
If they want to say, I don't need a guardian. And it's very common for elders who are in decline to become combative and refuse to accept that they need a guardianship. The court will hear them, and the court will appoint an attorney and allow that person to argue that they don't need a guardian. And it can come down to a battle of the experts where each side marshals their evidence and has a psychologist or a psychiatrist to testify to the person's capacity. It's not a fun role. It's a difficult decision for the court because it's a very serious thing. You're making an adult into a minor again, essentially. If I were to say Lee needs a guardian, I'm essentially saying Lee is no longer capable of functioning as an adult. He needs to be treated as essentially a minor, meaning not having legal capacity to act for yourself.
Right, yeah. I'm going to bring in, because I did social work for 30 years or so, an actual case The man is now deceased. I won't say what state of the union, was on the East Coast. There was this gentleman named Ivan. He had been, I think, a federal civil servant in forestry. Ivan was born in Russia, very brilliant in his heyday. I think he had taught forestry and other things. And one day, the landlord where he lived, he no longer was able to pay the rent. He used to pay the rent always on time. However, 1 month went by, still didn't get the rent. Second month went by, then the landlord, the superintendent, came to visit him and saw his apartment was a mess. His refrigerator had rotten food in it. The place was getting infested with roaches and other things. And on his table was a whole stack of bills, taller than I am, and other things, an uncashed Social Security check. This was enough of a clue that this guy was losing it. And so we at Adult Protective Services, I was worked with at that point in time, we petitioned the court to appoint a conservator. The person that he chose, and we asked his opinion, was the widow of his best friend. So somebody he trusted, he had known for years and years, and somebody he liked. So he also appeared at the court hearing. He was able to answer some questions for the judge, but he agreed that he was beginning to fall apart to some extent, and he needed someone to help him with his finances and read the bills and pay the bills and from his rent and all. We also, since it turned out he had been a veteran, we also found a way to get him admitted to the Veterans Administration Hospital. Well, they had like a Veterans Administration nursing home, and we were able to pull some strings and get him in. But from that case, I learned that you have to be able to understand what's going on, and you also have to win the confidence of the person, the patient, the client, who is the prospective conservatee, or whatever the word is. And so that case had a happily ever after ending, but I'm sure there are others out there.
Well, there's a real common trap, right, where that you identified,
Yes.
that a lot of elders fall for, and that's what I call the homebrew estate planning method. Or they just have a grandchild, or they have a child, an adult child, and they say, oh well, I want daughter Susie to take care of everything for me, so I'll just put daughter Susie on all my accounts.
Yes, daughter Susie.
And well, if Sue's mom was there and reaching, feeling like she can no longer manage her own affairs, there's a right way and a wrong way to get help. I'll tell you, the wrong way is to put a granddaughter or a daughter or one of your children or multiples of your children on all your accounts. Because if you put a child as a joint account holder with you, that child owns that asset just as much as you do.
Exactly.
Now there is a presumption. You can fight that presumption and say, okay, I didn't mean this to be a joint account for ownership. I only meant it for convenience, for helping mom. But that means you have to go to court and fight that out. And what'll happen is granddaughter or grandson has an accident. People are hurt. There's liability, and there's very sharp creditors out there wanting that money, and they find that account with the son or the grandson's name on it, and they say, show me why I shouldn't have all that money. That I've got a judgment for $1 million against this kid. Why can't I have all that money? It's in his name. That homebrew estate planning will kill you. And it starts when somebody finds grandpa or grandma not managing their bills anymore. And they do the quickest, cheapest thing, which is, well, let's just go down to the bank and put son or daughter on the account. And it's a disaster. The other reason it's a disaster is that if you end up applying for public assistance, Medicaid, for assistance needing a nursing home, if people don't realize Medicare won't pay for nursing homes. Medicaid pays for nursing homes.
Different, very different.
But there's a 5-year look back on gifts. When you make your application to Medicaid for helping you pay for your assisted living or your nursing home, you have to income qualify. You have to show that you can't afford to pay this yourself.
Exactly.
You pretty much have to be impoverished. And so people spend down their assets. Well, one thing that people like to do, they get the brilliant idea, well, if I give my assets away, I won't have these assets anymore.
Can't do
and
it.
then I can get on Medicaid and I'll be fine. Well, of course, the government figured that out and said, all right, we're going to have a 3-year look back. Well, then they changed that to a 5-year look back. And so when you make your Medicaid application, you have to show all the transfers of property to other people in the last 5 years. And if you've made gifts of property, if you've given away property for less than its value in the last 5 years, that can be disqualifying for you for a certain amount of time. So when you put your son or daughter's name on your house, that homebrew estate planning
Red
again,
flag.
well, it counts as a gift of half of your house.
Sure. Okay.
So not only do you have a problem with their creditors, but Medicaid may disqualify you from assistance.
Let me give you a hypothetical, because I have a family member who's undergoing this now. This family member has some disabilities. We won't go into what it is. She has a niece who's been a caregiver in another part of the country and is considering at this very moment having the niece come to live with her, find a joint 2-room apartment, whatever. Can she then pay the niece a good chunk of her money, of her bank account or her liquidated stocks, to lower her thing and use that as a legitimate way to diminish her assets?
Well, I'm going to let Susan take that, but I mean, yes, in general.
That's a sort of a social worky question.
Well, she can, as long as she's actually paying wages to the niece. She can't give a bunch of money to her up front, no, because that would be considered transferring assets. And,
can't you use it to pay the niece flying from a different part of the country here as part of as not as a gift, but, and...
Yeah, I think legitimate expenses, and that would seem
particularly
to be
where there's a language barrier, particularly where if the relative, I'm familiar with communities that have language barriers. If you want a relative who speaks the native tongue of the grandparent or the elder, I don't think anybody would question that bringing that person here to work as a caregiver, but it has to be honest work. It has to be a real job. It's not just a way to pass assets down in the family. So yeah, you have to pay a reasonable wage. You can't be paying $100 an hour when the common market rate for the home care services is $12, $13 an hour, that kind of thing. You pay the person the same, the going rate for the services as if you weren't related. And there are a number of actually programs designed to help people because it's cheaper if we can keep elders out of the high-cost institutions.
Yes, of course.
They are willing to allow people to pay family members to try to keep them out of the high-cost institutions. Everybody's happier. Mom or dad are happier in their own home. It provides needed work and employment for the younger generation, and keeps a bed open in the high-cost facility for somebody who really needs it.
And I want to just mention here that kind of a situation has, it seems like it's a perfect answer to the situation, to the need of both people and so forth. But it seems to me like, I'm saying this from personal experience, that it be really important that niece, in your example, does not have carte blanche with writing checks and that sort of thing, paying for expenses. Because I was involved with a person who gave her niece that kind of access to her accounts and so on, and the niece went off with a lot of money, and it turned out that Adult Protective Services were called, and there was an investigation, and the person was booted as a caregiver and a guardian for her.
Good point. Good point.
And that person appointed her herself. It didn't go through the courts.
I will tell you, I attended a child abuse presentation yesterday, and the sad truth of child abuse is that it's a family thing. the strangers don't molest kids much. Mostly it's family members, trusted figures, coaches, it's people they know abuse children.
They build on the trust, and then they betray the trust.
Right, but the flip side of that is who abuses elders? Again, it's rarely the stranger. It can be, but it is often the family member who, for whatever reason, has forgotten their duty. And, family members, they can easily get, they can calm or they can allay the suspicions of strangers. Oh, I'm so-and-so's daughter, so here I am. Yes, of course you should let me write this check. Because you know so-and-so, and you've known so-and-so for 50 years, so now I'm so-and-so's daughter, let me write this check. I think it's a great point. Don't make your caregiver your conservator just because it's convenient. If they want to care for you...
all conflict, sometimes.
It's easy for that person, especially if there's a language barrier, to isolate you.
Yes.
And elder isolation... the caregiver who isolates you from everyone else can be a real threat. And so by not making one person both the essentially guardian and conservator, you ensure that there's at least two people, one to keep an eye on the other, essentially, is what I'm suggesting.
Yes.
Yeah. I want to follow up on Susan's mention of adult protective services. That's the counterpart to child protective services. And this brings to mind a very creepy case. I can use the word creepy, non-clinical term. What happened, and this happened in, I think it was either Maryland or Virginia, doesn't matter, the East Coast. There was an elder client of mine who had some disability, and she was getting Social Security check, not that much, but she had a grandson who was on a drug habit. Sometimes drugs are a big threat to the stability of the older generation. And he had a girlfriend and even had an out-of-wedlock kid. So somehow he got stronger than his grandma, and he moved in, I guess rent-free, to live with her. And he used his influence in an evil manner. What he did was he ripped off some of her Social Security money in order to pay for those drugs.
Yep.
Not a good thing to do, actually very malevolent. And I was just investigating the case. Now, in addition to this, he was a mechanic, but of course he wanted to get his money off the books. So what he would do is he would take cars from the neighborhood and put them in front of the house, and he would work on them, the engines, the batteries, etc., etc. One day, he put a car in front of the house and boosted it up on cinder blocks, and he went underneath the car. Somehow, those cinder blocks, by force of gravity, slipped, and he was crushed to death. That was the way that the case ended, and the grandma was able to regain access to the Social Security checks, and she didn't bat an eyelash at his funeral when he died because she kind of felt he had it coming to him. So that's a very bittersweet ending, but a reality thing.
It is, and another reason, when I warn that you really should make sure there are checks and balances built in so that somebody doesn't take your money or spend your money for their own purposes. That's the one reason. But many people listening to us will say, oh, well, my niece wouldn't, or my neighbor, or my friend, or my anybody. They wouldn't.
Gullibility is the name of the game.
Well, the thing is, it's tempting. It's tempting for people to use the other person's money just till I get my own, just I'll pay back and so on. But when you build in those checks, they have to account to somebody. It's a big support to them.
It keeps honest people honest.
It does. And if there's any question, very often older people get a little paranoid. They get worried about their money, or how you're spending it. Maybe you're taking it, or anything, many older people with dementia get concerned that somebody's taking their stuff.
And I've heard people
and
say,
that's very protective for the person who has who's working in there, but has the check and balance.
Yeah. They say, will I outlive my money is another concern. I want to ask you, you've been an ombudsman, or you work with the ombudsman. Let's tell our audience out there, what exactly does an ombudsman do? And if somebody in your family needs it, when is it appropriate to?
Very
So
good.
knock, knock, ombudsman wanted.
Yes, well, the situation I was talking about that I had been involved in, where the person appointed a niece to be your guardian, and not officially, but unofficially. And then she ended up being investigated by Adult Protective Services. It was an ombudsman that called Adult Protective Services, or didn't really call, but encouraged
Alerted them or whatever.
the family to call. And the ombudsman's role is to look out for anybody in long-term care. So adult foster care, assisted living, nursing homes, residential care, those people.
But not independent living, really, I think.
No, not independent living.
And that's sometimes they get away, because I've known of some things in independent living places here in the Salem community that are questionable.
Yes, and the state ombudsman is appointed by the governor, and then many certified ombudsmen are trained, 4-day training. They need volunteers, so we'll put the number on the screen.
Ombudsman, get down this number and keep it close to your heart. Yeah.
Anyway, so there's this 4-day training, and then you're assigned to one of these residential care situations for long-term care. And then that person visits there regularly and has their name and phone number up and so forth. And their job is to look out for the interests of people who are in long-term care. So any issue, but especially things that require protective services, would come to the attention of the ombudsman.
Let me raise a logical question, because I've worked with the elderly, and I know there's a certain fear of upsetting the apple cart. Older people tend to be a little more conservative and more fearful. Is there any way to make sure that if an older person becomes a whistleblower, in a sense, and alerts an ombudsman that such and such is going on and being investigated, that there won't be retaliation against that older person? They'll be kicked out, or they won't be getting the same food as everyone else, or some other tactic that would strike fear into their hearts?
Yes, there is. The ombudsman,
It's important to know.
once called, will not abandon you. So you're called as the ombudsman. You work out the conflict there, and then the question is, will they treat this resident the same? But the ombudsman's there to check all the time.
Investigate.
Right, and they will not hesitate. It's against the law to retaliate. It's against the law to not provide the services that the person is paying for.
Yeah,
so.
the thing that then comes to mind is, would it be a waiting game like they were doing in Iraq? We won't go into that today. But let's say the ombudsman comes, investigates, finds something that is an accurate accusation of some abusive thing. And then do they close the case and then they withdraw? Or is there a possibility that after the case is closed, that there'd be a delayed reaction retaliation? You know what I'm saying?
Yes, I do know what you're saying. And there's always an ombudsman available. And as long as the person remains in the same facility, the same ombudsman will probably be there long-term for them.
Okay.
But always the ombudsman's office can be called.
Okay.
And
also, if
Yes,
there's a substantiated allegation of abuse and neglect, I mean, if there's a report against, let's say it's a facility staffer, or the facility in general is not treating an elder properly in their care, or if an elder is in an assisted living and someone observes that the elder's family might be doing something hinky. Well, and the facility is not if the facility is not protecting this person, I mean, they have an obligation to ensure that this person is protected. That's why they're in those facilities, is because they can no longer live on their own.
Right, they are disabled to some extent.
If there is a substantiated allegation of abuse, meaning after the investigation has gone in and they've decided, yeah, this probably did happen this way, the facility is required to come up with a corrective action plan, and that plan has to be submitted to the state and approved. So the ombudsman is one of the players in making sure that that corrective action plan is implemented. It isn't, the event just didn't happen and is forgotten. And the facility can be fined for bad events and also for failure to properly rectify and prevent future occurrence.
Okay.
And for some very substantial abuse, private attorneys can be called and private actions can be brought.
Okay. I'm going to play devil's advocate for a minute. When somebody is going to apply for admission to a given assisted living home, for example, is that assisted living home required, or is there a way that the potential applicant could find out if they've been fined or had any cases of abuse so they know the reputation?
Absolutely.
So
Absolutely.
And how would they do that? Because, let's say I wanted to have my sister go into an assisted living home and I wanted to make sure that it had a clean record. How would I
The
check that
quickest
out?
way is through the Ombudsman's office. There are links, I believe, on the Ombudsman's website to the quality of care reporting statistics.
Like a
Yes.
Better Business Bureau, sort of.
Yes,
Yeah.
absolutely. And it's been a big effort federally and statewide to try to give people access to this important information. The other important information, not just the paper statistics or the statistics you can get from the Ombudsman, but it's so important to go visit the facility where you're thinking of placing your elder, and go visit on the back shift and on weekends. If you just
Excellent.
visit at 10 o'clock on Monday morning, you're going to get one perspective on the place. And what you need to do is be there at 8 at night and on Saturday night sometime, and to see what the night crew looks like, and to see what the level of care and what the level of activity is on the back shifts.
And also to learn about the staff turnover. Because if the staff is discontent and people, the management and all keep rotating jobs, and one week they're there and the next week they're out.
Right. You can ask
That's a
about
danger
that.
signal.
You can ask about all of that, and ask the ombudsman who's been serving the facility what's their view of the facility. I mean, the killer question is always, would you put your mom here? And that's the question you want. You want to put your loved one or your family member or the person you care about in a facility where everybody says, yes, I'd put my mom here. There are such facilities. It's a tough business, though, and so you need to be alert to the fact that there's a fixed pot of money. These facilities are all, very few of them are well funded. They're a business, and as a business, money is their lifeline. And if they can cut costs, and they keep more money if they cut costs.
Sure.
And staffing is the primary cost of a care facility. So you always have to make sure that you're comfortable with the level of staffing. And again, as I say, don't just take the guided tour. Come back at a few other times,
yes.
so that you can see what it looks like when when they don't know you're coming.
Okay. Let's turn again to the people still living at home, not in an institutional setting. Power of attorney is very important. Two kinds. One is about finances, and these things need to be planned before you retire. Now, this city has a lot of civil servants here, mainly state workers here. Some of you watching today are probably state workers or retired state workers. I think it would be helpful if the state cooperates as part of their pre-retirement seminars to give things on estate planning and all, so that they could educate potential retirees about what they're facing and get them to look at the whole picture, including events directives. Susan, would you like to tell us a little bit about your thoughts on that?
Well, one thing that occurs to me is that a power of attorney, a lot of people will wait too long for that.
What is it? Explain to the guys and gals out there, a power of attorney is ...
Well, you could probably do a more succinct.
Go, John.
It's a
Yes.
it's a legal permission slip for someone to take certain actions on your behalf. We commonly refer to the slang term, the general public says, I'm power of attorney. It's not it. I'm an agent. Really, a power of attorney is a legal form that you use to give someone the power of attorney, and that person is your agent.
Proxy, sort of.
Well, it is a good term. Attorney, the word attorney was from Old French, and it meant to turn over. You turn over a problem to an attorney, and the attorney handles that for you. A power of attorney means I'm turning over certain tasks to my agent. I want the attorney to pay my bills for me. I want this agent to look after my trust, or I want this person to handle my taxes for me. Okay. Anyone who's acting under a power of attorney is called an agent, and they have exactly the powers that are described in the legal document. The difference between an agent under a power of attorney for finances and a conservator is that no bank or insurance company or any other institution has to agree to act as your agent directs. The agent can bring them the power of attorney and say, hey, Mr. Bank, I want to take the money out of this account because I'm the agent for Susan. Susan has appointed me her agent under this power of attorney, so you should let me withdraw this money. And the bank could say, no, that Gear guy, he looks pretty suspicious to me.
I agree.
Yeah, well, and the bank has the duty. If they're not comfortable with that, they can say, no, we don't think we buy that. We don't like that. So that's what a conservator is a conservator. Now, the conservator can force the institutions to act, to let you act on their behalf.
A lot more power.
It's the real power. It's not deniable. Now, I write very broad powers of attorney sometimes for clients, and I basically say, this agent can step into the shoes of the principal and do anything the principal could do. Buy and sell property, pay taxes, start a business, sell stock, buy stock, open credit, take loans, do anything the principal can do. But I also tell people, when I've given them such a powerful device, I say, if you really want to make sure this works, you, while you're still competent, go with your agent and you go to the bank, to the credit card company, to the insurance company. Go to the places where you're going to want this power of attorney respected. Introduce the agent to the banker, to the insurance broker, to your real estate broker, and give them a copy of that power of attorney. If the principal and the agent go together, and the principal, the person who's giving the power of attorney, actually introduces the agent to the third parties who are expected to honor that power of attorney, it's probably going to go a lot better. If some kid with a tattoo and a nose piercing shows up with a power of attorney and says, Grandma gave me her power of attorney, I'm here to sell the property, it might not happen. But if that kid has been introduced to the real estate broker years before,
so familiarity helps.
Then it's clear. There's a comfort with the fact that yes, the principal really did want little Johnny to be able to do that.
Okay. I want to ask.
Well, I just wanted to mention that
Susan.
I have given power of attorney or made my brother my agent through a power of attorney.
Right.
And I asked him if he would do it, and he said yeah, and so I signed it and all that. And has to be notarized, right?
For best effect, yes. Not actually, but it will increase the comfort level of the people who are expected to honor it
Seal of
if
approval.
there's a notary stamp on it.
Yeah, I think I had mine notarized. But anyway, it
also.
says on there, and this is the agreement I have with him, in the case that I would not be able to do it for myself, or I ask him to do it.
Right.
And so if I got in a car wreck and couldn't do anything, then he would take over. if I got dementia and was
Right.
not able to carry out my thing. So it's all finished, it's there, but it won't be ever take effect until I need him to do it.
Right, and by doing that under a power of attorney, you have increased your chances that it'll work. But if you haven't introduced him to your banker, to your insurance broker, to your landlord, to the people who you have financial dealings with, there's a chance that they might say, well, how do we know she's disabled? I just talked to her last week. She didn't say anything about this.
My experience being that having power of attorney for a friend was that sometimes the bank would ask me quite a few questions.
Yep.
And I could refer them to people.
And they're trying to
check it
assure
out
themselves.
and that sort
right.
of thing. Yes.
Well, but you asked about notarization. Let's talk about the other kind of advanced directive.
Let's hold this up to the camera.
Okay, well, this is a booklet. I'll try to get the glare off it. This is called Advanced Directive, Your Life, Your Decisions. This is Key Conversations. This is what Oregon, in other states, they would call a medical power of attorney. In Oregon, it's called an advanced directive. And it's where you appoint someone to be your agent for your health care decisions if you can't express your own wishes.
Yeah, why would you do that? Give us an example.
I think the
typical situation.
Well, it's built into the name. The person you appoint using this advanced directive for medical care is called your healthcare representative.
Okay.
And so that's exactly why you need somebody. If you have a stroke, if you're unconscious, if you have an accident, or if you just become so victim of dementia that you're not able to make good decisions anymore to care for yourself, you have previously outlined your wishes for your long-term care, whether you want heroic measures for your life-saving, whether you want to be put on a ventilator or not. There's a ton of good discussion in this booklet that if you go through it with your healthcare representative, you express your wishes to them, you do it in writing and by telling them, and you make sure they agree. And there's a place for you to sign and make this an official appointment.
And give it to your doctor.
Well, you sign it, but then the person who actually accepts the duty to be your healthcare representative also has to sign it.
You need a copy.
And there has to be witnessed by 2 witnesses, not notarized, but witnessed.
Okay.
And then if you do that, then you take and you make sure your doctor has a copy. You make sure the hospital that you use, if you've had a lot of care,
Salem
make sure that it gets
OHSU.
make sure that it gets entered in their records. And you greatly, greatly increase the odds of having your wishes respected if there is such a document. If you wind up in the hospital one night after a cardiac event or a stroke or an auto accident or a slip and you fell down the stairs, if you don't have such a document or they don't know how to find that document, you'll get whatever the standard of care is that the doctor in charge thinks you deserve to get. And that's probably going to be every life-sustaining measure, whether you would have wanted that or not. I sometimes cynically say you'll be treated to the last dollar of insurance. But the medical people are in a bind. If they do less than everything they could, they're afraid that someone will go after them for that. So this is really important that you appoint somebody who knows your wishes, and that those wishes are also known to the medical people who you're likely to encounter. Your odds of having those wishes honored and respected, not ending up tied to a machine, go way, way up.
And I want to...
let me just ask something. Or this is not quite lobbying. I would like to see, and I hope other people out there would support this, having these particular advanced directives which deal with healthcare available at every motor vehicle bureau thing. Why? Because if you drive a car, there's always the possibility that you will get into an accident or somebody you hit could get into an accident and have
That's a great idea.
A life-threatening thing. I would like to see also the insurance companies out there. Listen, if you sell insurance or know an insurance guy or gal, that those people who have that might get a discount or reduction on their insurance because they've thought ahead of the game. That would be an added incentive, maybe.
Don't know if it'll make them safer, but I'll go you one better.
Go.
I believe that every young person getting out of high school, either at age 18, ought to be encouraged and taught about appointing one, even at 18, or if they are graduating before 18, prepare it so that it's ready for signature at age 18. Because the saddest case is not the 75-year-old who doesn't have an advance directive. It's the Terry Shivos, the 30, the 20, and the 18-year-old who ends up on a ventilator for Lord knows how long because they don't have an advance directive. Young people think they're immortal.
Yeah. Well, car accidents are one of the principal
Car
killers
accidents, firearm mistakes,
people,
diving accidents. There's all kinds of reasons that young people need to have advance directives too. We're all young people in our own minds, even as we age. But you know, at age 18, your parents can no longer make some decisions for you, so all adults need to have a health care advance directive in place. And those adults with a lot of assets, of course, probably do need to think about a financial power of attorney as well.
I was just going to mention that I think you can't do it too soon. And
before 18, you can't do it.
Yeah, well, that's true. But many of our viewers will think, well, I'm not old enough to worry about that.
Oh,
but
right.
If you think about what it would be like if nobody was speaking up for you when you're in the hospital and you couldn't, the doctor's asking you, do you want this or that, or deciding for you what you should have, and you couldn't refute it, or you weren't sure that you could think through carefully enough, or so on, and you had nobody there to do it for you, that would be a terrible pickle, and that could happen anytime.
Or worse, there's conflict.
I wonder if the armed forces requires having an advance directive to sign up because you're vulnerable to gunfire and other type of things.
Not that I know of.
Yeah, that's something for the congressmen and women, Bonamici and Schrader and others. And listen up, Ron Wyden and Jeff Merkley. There's some legislation for you to go on.
Well, actually, if you're in the service, they will make decisions for you, whether you...
Yes, okay.
You don't have to worry that you will not have decisions made for you in the same way in a civilian life.
Yeah. We have about a minute to go. Are there any closing thoughts? Let's do alphabetically Gear, because before Jones, I'm going to pass on this. Mr. Gear, what are your closing thoughts for the one thing that people should remember from this program?
You don't know how long you have left. No matter how old you are, you don't actually know how long you have left.
And therefore
everyone should prepare to meet their demise. And it's not gory and it's not grim. It's actually, everyone who's done estate planning with me feels better because they know that's in order.
Susan has about 30 seconds.
I would say you don't know what could happen to you, and to be compassionate toward those who are left and they have to deal with it. You can tell them what you want, and give them the power to do it, so they don't have to go through all kinds of hoops.
It is a very blessing on them to do that.
Okay. This is Lee Coyne signing off for the Senior Symposium on Disability. We hope you take down all those numbers and follow up. See you again, and have a happy, healthy summer. Bye for now.